This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Today we have yet another Liebowitz fair use case. Liebowitz is really doing a great job here helping establish the boundaries of fair use. We're going to take a look at a decision from the United States District Court for the District of Arizona in Daniel Fellner versus Travel for All Seasons. I believe Travel for All Seasons is defended by Dan Booth from Booth Suite, and once again, I'm very thankful to them for defending copyright fair use against copyright troll Richard Liebowitz, who has been suspended from the Southern District of New York, but has not been suspended from the District of Arizona, I assume. This matter is before the court on defendants, motion for summary judgment, and all the responses. During the course of discovery, it appears that plaintiff requested hardly any discovery, and he did not depose defendant or its principal, Alfred Haig. Although Mr. Liebowitz filed the response to defendant's motion for summary judgment on behalf of plaintiff, he is no longer plaintiff's counsel of record. Okay, so that kind of answers that question. Mr. Liebowitz has filed hundreds of similar actions in federal courts throughout the country, has been repeatedly cited for misconduct in this district and many other federal courts throughout the United States. Yeah, maybe he shouldn't have done that. Plaintiff filed his 4-page complaint on March 13th, 2019, alleging one count of copyright infringement under Section 501 of the Copyright Act. And we have that here. And so it's a very simple complaint about Fellner wrote an article about pickleball on cruise ships. That's Exhibit A. Here is plaintiff's article. Pickleball is a fast-growing sport. It is a racket sport that combines elements of tennis, table tennis, and badminton. Paddles are made of wood or composite materials. The ball resembles a wiffle ball. The sport can be played with 2 or 4 players. Doubles is far more common. Fellner is the author and has been a sole owner, and it's registered copyright. And so then Travel for All Seasons ran an article entitled Pickleball in Demand on Cruise Ships, and they did not license the photographs or the text to do so. So that's Exhibit B. And so Travel for All Seasons magazine, pickleball, fastest growing sport, racket sport that combines elements of tennis, table tennis, badminton, etc. Plaintiff is a professional photographer and journalist in Arizona. Defendant operates a website, its sole asset, which publishes informational travel articles. The only member of defendant is Alfred Haig, a disabled military veteran who operates the website as a hobby for other travel enthusiasts like himself. Defendant does not have a bank account and has never earned any revenue from the website. Plaintiff alleges that defendant reproduced, without permission, a copyrighted article that plaintiff wrote about pickleball on cruise ships. Plaintiff's article was previously published by AZ Central and USA Today and was copyrighted. Plaintiff alleges that defendant published the entire article, including photographs and text, on its website without permission. Plaintiff demands statutory damages of $150,000 and attorney's fees and costs. Defendant argues that it did not post any of plaintiff's photographs, and further that it only posted a portion of the article on its website. Defendant argues that its posting of the article falls under the fair use doctrine and does not violate the Copyright Act. So then the court goes into the summary judgment standard. The movement must show that there is no genuine issue of material fact and that they're entitled to judgment as a matter of law. And so if there's any dispute, it goes to a jury. The moving party bears the initial burden of identifying the portions of the record, including pleadings, depositions, answers to interrogatories, admissions, and affidavits, that it believes demonstrates the absence of a genuine issue of material fact. If the moving party meets its initial burden, the opposing party must establish the existence of a genuine issue of any material fact. There is no issue for trial unless there is sufficient evidence favoring the non-moving party. If the evidence is merely colorable or is not significantly probative, summary judgment may be granted. However, the evidence of the non-movement is to be believed, and all justifiable inferences are to be drawn in his favor. So I'll skip the rest of that, but the point is we're on the summary judgment standard, which is not the same as going to a jury trial or even a bench trial. Under the Copyright Act, copyright protection subsists in original works of authorship fixed in any tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated. Generally, unauthorized use of copyright materials is not permissible. However, unauthorized use of copyrighted material is allowed in certain circumstances. The fair use doctrine was initially developed by courts as an equitable defense to copyright infringement, in other words, a fairness defense. Essentially, the doctrine creates a limited privilege in those other than the owner of a copyright to use the material in a reasonable manner without the owner's consent. Congress later codified this legal doctrine in 17 U.S.C. Section 107. However, Congress expressly sought to preserve the doctrine's common law character, leaving courts free to adapt the doctrine to particular situations on a case-by-case basis. Courts are to consider 4 factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the whole, and the effect of the use on the potential market for the copyrighted work. The task is not to be simplified with bright-line rules, for the statute, like the doctrine it recognizes, calls for case-by-case analysis. Fair use is a mixed question of law and fact, but if there are no genuine issues of material fact, or if even after resolving all issues in favor of the opposing party, a reasonable trier of fact can reach only one conclusion, a court may conclude as a matter of law whether the challenged use qualifies as a fair use of a copyrighted work. The statute encourages courts to apply an equitable rule of reason, or fairness, to particular claims of infringement. The court must determine whether defendant has established fair use of the copyrighted article. If so, defendant is entitled to summary judgment on plaintiff's single claim of copyright infringement. As an initial matter, defendant argues that plaintiff has failed to proffer any admissible evidence to dispute the facts established in the motion. Plaintiff provided a declaration of Mr. Liebowitz, unverified interrogatory responses, and copies of the article. Defendant argues that of the evidence provided, only a single statement can be supported with personal knowledge by Mr. Liebowitz that he is lead counsel for plaintiff Daniel Fellner. The court agrees. Plaintiff submitted no authenticated documents, declarations, or admissible evidence of any kind to establish that there are material fact disputes. Under Rule 56E, if a party fails to properly support an assertion of fact or fails to properly address another party's assertion of fact as required by Rule 56C, the court may consider the fact undisputed for purposes of the motion. As plaintiff did not provide any admissible evidence to dispute any facts established by defendant, the court determines there are no material facts in dispute. The court will turn now to the fair use factors to determine whether plaintiff's use of the article was fair. So that says to me that there was a major failure on plaintiff's part, and I'm assuming Leibowitz's part, that there was no evidence submitted, no admissible evidence submitted, and that the only statement that could be admitted was that plaintiff's attorney is his attorney. That's it. So let's see what the court does with this from here. The first factor requires that the commercial or nonprofit character of an activity be weighed. The crux of the profit-nonprofit distinction is not whether the sole motive of the use is monetary gain, but whether the user stands to profit from exploitation of the copyrighted material without paying the customary price. A challenge to commercial or non-commercial use of the copyrighted work requires proof, either that the particular use is harmful or that, if it should become widespread, it would adversely affect the potential market for the copyrighted work. A plaintiff must establish by a preponderance of the evidence that some meaningful likelihood of future harm exists. Plaintiff asserts, without supporting evidence, that defendant profited off of the use of the article. If defendant had published the pickleball article for a profit-making purpose, such use would be presumptively unfair under this factor. The contrary presumption is appropriate here, however. Defendant has established that the article was not posted for any commercial purpose, and indeed did not make any profit. Alfred Haig, sole owner of the website, testified that the website is a blog for travel enthusiasts like himself to read. The information on the website was fully accessible to the public and did not require a membership fee. Moreover, defendant has not made a profit from the website and does not have a bank account. The court also considers that defendant identified plaintiff as the author of the article and provided a citation to the original work in order that any visitor to the website could read the article in full. Defendant has since removed the article, so it will never earn a profit from it. The court finds this factor weighs in favor of finding fair use. On the nature of the copyrighted work, the court considers the nature of the article. The law generally recognizes a greater need to disseminate factual works than works of fiction or fantasy. The likelihood of finding fair use is greater when informational as opposed to more creative works are involved. Plaintiff argues that his article was not a factual work, but a creative work that only he could have written. Moreover, plaintiff argues that because defendant did not transform the article or add commentary to it, that this factor favors a finding of copyright infringement. While the work included some of plaintiff's opinions, the majority of the work was a summation of the history of pickleball and its current popularity on cruise ships. For instance, one paragraph explained, quote, "Pickleball is a racket sport that combines elements of tennis, table tennis, and badminton. Paddles are made of wood or composite materials. The balls resemble a wiffle ball. The sport can be played with 2 or 4 players, although doubles is far more common." Another paragraph states, quote, "Pickleball was invented in the 1960s in Washington state, but only recently has seen a huge growth in popularity. It now routinely attracts more players than tennis in age 55 and older housing developments. The USA Pickleball Association, which is headquartered in Surprise, Arizona, calls it the fastest growing sport in North America." The article is much closer to a news story than a motion picture. Moreover, only one of the 7 paragraphs published on defendant's website contained personal observations from plaintiff. The court finds that the majority of the article is factual in nature and not an original piece or novel. Moreover, while defendant did not add anything of substance to the article to substantially transform it, that is not required for a finding of fair use. Transformative use is not absolutely necessary for a finding of fair use. The court finds this factor weighs in favor of finding fair use. Amount and substantiality of the portion used. The court must determine the amount and substantiality of the portion used in relation to the work as a whole. Plaintiff alleges that the defendant published the entire article, including photographs and text, on its website without permission. Plaintiff, citing to Leibowitz's declaration, argues that defendant has taken the vast majority of plaintiff's literary work and republished it on its website. Ironically, the vast majority of plaintiff's response appears to have been copied and pasted from other briefs by Mr. Liebowitz, as the response almost exclusively discusses the theft of photographs, not written text, and most of the law cited is from out of this circuit. So Leibowitz copy-pasted his own argument and didn't tailor it to the argument he was making in this case. Irony. Defendant argues that it did not publish any of plaintiff's photographs on the website. Moreover, defendant argues that it did not publish the entire article, but only a portion of it. Plaintiff's allegation that defendant published the entire article are clearly false. The original article, published in the Arizona Central, contains 16 separate photographs. The evidence is undisputed that defendant only published 7 paragraphs of the article on the website. In terms of the substantiality of the article published by defendant, it did contain the main factual portions of the article, but it did not include the more creative portions, such as plaintiff's interviews with the president of the National Pickleball Association, cruise ship activity directors, or cruise ship passengers. Therefore, the court finds this factor slightly favors a finding of fair use. And the effect of the use on the potential market. Where the use of a copyrighted work has no demonstrable effect upon the potential market for or value of the copyrighted work, it need not be prohibited in order to protect the author's incentive to create. A plaintiff must show by preponderance of the evidence that some meaningful likelihood of future harm exists. Plaintiff argues that the market for his work was diminished because of defendant's unauthorized publishing of the article. Plaintiff has provided no evidence to support this assertion. Plaintiff attempts to label defendant as a competing news organization with the organizations that paid to publish plaintiff's article, Arizona Central, and later USA Today. USA Today has a daily readership of 2.6 million people and has thousands of employees, whereas Mr. Haig is the sole operator of defendant's website. Plaintiff has not provided any admissible evidence to suggest that defendant is a competing news organization of USA Today, such that the article's reproduction by defendant would reduce its economic viability with other large news organizations. It is undisputed that defendant has never made a profit from the article. Moreover, plaintiff has not established that the unauthorized reproduction reduced plaintiff's economic opportunities in the market. The court finds this factor weighs in favor of finding fair use. At its core, fair use presupposes good faith and fair dealing. The undisputed facts establish that defendant did not reproduce the article to attempt to gain a financial benefit to plaintiff's detriment or for any nefarious reason. Defendant simply thought the topic of pickleball and cruise ships would be interesting to the relatively few readers who visit his website. There is no evidence to suggest that defendant's use of the material was anything other than fair, and all 4 factors weigh in favor of finding fair use. Plaintiff has provided no admissible evidence to the contrary, and the motion for summary judgment will be granted. Accordingly, summary judgment is granted. Clerk to enter judgment. That is the Honorable Diane J. Humetawa, United States District Judge for the District of Arizona. So that's remarkable because 2 things. 1, you can post portions of a factual article to your relatively unknown website that a few of your friends read, and that might be considered fair use. But also 2, once again, Liebowitz has totally screwed up a fair use case by not presenting admissible evidence. He didn't present declarations, he didn't present verified responses, he didn't depose defendant or its principal. So he didn't put the time into the case, possibly because he didn't have time to put into the case because he's so busy being a copyright troll and getting all of these misconduct violations and sanctions and disbarred from Southern District of New York and all that. And maybe that's just too much for him to be able to prosecute every single case. Which is why lawyers have a Rule 1.1 duty of competency under the rules of professional conduct, that they have to conduct themselves only to their level of competency. They cannot take on too many cases or take on cases that they are not competent to handle. And yes, that involves the lawyer's own subjective determination of whether they are competent, but also involves the bar's determination of whether that was a reasonable decision. So in this case, in the case of Liebowitz, it sounds like he's not Rule 1.1 competent, not because he can't figure out copyright cases, but because he's had too many of them and too many violations and too many sanctions and et cetera, et cetera, et cetera. There's too much going on in his practice and maybe in his life. He's not competent to handle this many cases. So hopefully he gets that under control before the state of New York formally disbars him, but who knows? We'll see. I'm still to this day, I'm reassured that as long as I'm not this bad, I'm never going to lose my law license. And at the same time, I am appalled that someone could have this many violations and not lose their law license. So it's a double-edged sword. Let me know what you think in the comments below. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of January: Joe Tyson, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, HotGrillsInYourArea, Torpedan, Brandyn Abel, Cassandra Curran, Sovereign Tittizen, ShadowTycho, RDHDragon, Earthbound Star, Nathan McCarty, and Awful Asses with Lemon Fresh. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.